Family Law Cohabitation Investigations by Randall Alexander, paralegal and licensed investigator.
Chapter 1. Introduction. Modification of support is a common area of contentious litigation, where investigators are brought in to establish evidence in support of their client's litigated matter. In family law litigation, cohabitation investigations can be financially beneficial for the client in the form of reduced or terminated support, if the facts and evidence support the client's assertion. However, cohabitation cases have frequently resulted in a disconnect between attorneys and investigators due to poor litigation results, while futilely expending the client's financial resources. In my opinion, the cause lies in a few generalized areas. The attorney or client may have had a poor prior experience with an investigator, resulting in reduced expectations from our industry. The investigator may not be experienced or trained in family law and does not quite understand the evidentiary needs to meet the elements of cohabitation suitable to meet the burden of proof. The client's financial constraints may inhibit the investigator's ability to conduct a thorough investigation, or the client misrepresented or fabricated the alleged facts, hoping for an advantage in the courtroom. This is where excellence in all three areas of a professional investigation is paramount for success. Investigative expertise, knowledge based on training and experience. Comprehensive reports, detailed reports that link relevant facts and evidence. Expert testimony, professionally articulate the facts under oath. Chapter 2, Cohabitation defined. Living together as husband and wife. Cohabitation means having the same habitation, not a sojourn, a habit of visiting or remaining for a time. There must be something more than mere meretricious intercourse. Cohabitation is far more than just a third party spending the night with a supported litigant or vice versa. An investigator needs to understand cohabitation in a legal sense in order to focus his/her investigation in meeting the elements.
Family Code Section 4323A1. Except as otherwise agreed to by the parties in writing, there is a rebuttable presumption, affecting the burden of proof, of decreased need for spousal support if the supported party is cohabiting with a non-marital partner. Upon a determination that circumstances have changed, the court may modify or terminate the spousal support as provided for in Section 3650. California Civil Code Section 4801.5a. Except as otherwise agreed to by the parties in writing, there shall be a rebuttable presumption, affecting the burden of proof, of decreased need for support if the supported party is cohabiting with a person of the opposite sex.
More insight into the elements of cohabitation can be found in the appeal in Remarriage of Leap, 1978. In Leap, the courts found that cohabitation existed where the supported party and her partner treated themselves as mutual homemakers, housekeepers, companions, exchanging expensive gifts and taking vacations together, etc. The family courts, with regards to subject matter jurisdiction, have tremendous latitude compared to other areas of law when making decisions, where determinations are made on a case-by-case basis. Rarely will you find a smoking gun in a cohabitation investigation. Therefore, it's critical for the investigator to exercise due diligence when conducting their cohabitation investigation, proverbially uncovering every evidentiary stone. I prefer to look at the compendium of evidence as a brick wall, where every single brick is important and not individually exclusive to the success of the case. This overwhelming compilation of direct and circumstantial evidence eliminates the rebuttal of isolated incidents or lone issues that may otherwise be easily refuted in court. The attorney will want to know, does the supported party and new significant other, third party, share one household? Does the supported party or the third party benefit from the client's financial support? Does the supported party financially benefit from the new significant other? Is the supported party and third party in an intimate relationship or just roommates? What evidence supports these contentions? Where to start? Once we have obtained relevant background information from the client, the first step is database research. Chapter 3, Investigative Research. Court documents. Request a copy of the opposing party's income and expense declarations, submitted personal declarations, and/or depositions. Review these documents and keep critical details in mind when conducting your investigation. Contradictions and undisclosed facts by the supported party may demonstrate dishonesty in the eyes of the court. Also check if the current third party, new boyfriend or girlfriend, is in the process of family law litigation themselves, which is common. If so, pull the docs and review, cross-referencing information that may support your client's case. Database research. First, consider database reports are never considered conclusive or definitively accurate. They are merely an investigative tool. In fact, most database companies attach a caveat to their reports advising that database reports are replete with errors and subject to human error and must be independently verified. Moving forward, database research on both the supported party, SP, and the third party is always the first step. I always run 3 different data brokers. It will usually reveal supportive leads in the form of an address history for both the SP and the third party. There are several things to look for. Did the supported party or the third party recently move in with the other, and is it reflected in the report? If so, it's important to follow up on the last known address of either, demonstrating they vacated their previous address before moving into their new residence. Did either person open a post office box in the area to possibly conceal their current residence? If the database reports accurately support your client's case, detail this in your report and explain how database companies rely on credit header personal identification information, which is collected monthly and provided by consumer credit agencies, Experian, Equifax, and TransUnion. On the other hand, the database report may reveal the SP or third party actually does maintain separate households. It is up to the investigator to determine if the additional residence is lived in by one of the parties, or is it used by other extended family members, or possibly even used as a rental to generate additional income. This is important to determine early in the case, which could have an impact on whether cohabitation exists and whether the case should continue forward. If children are involved, the database research may also reveal a history of violence or substance abuse by the new boyfriend/girlfriend, which may have an impact on custody. Social media. Social media can be extremely helpful depending on the degree of use by the supported party and/or the third party. It may reveal intimacy, trips together, shared events, holidays, etc. If children are involved, check their accounts as well. Immediately preserve the evidence in the form of print, downloads, and screenshots. Then refer to them as attachments in your reports.
Note the California Evidence Code 1552A, addressing computer-generated evidence reads, "A printed representation of computer information or a computer program is presumed to be an accurate representation of the computer information or computer program that it purports to represent. This presumption is a presumption affecting the burden of producing evidence. If a party to an action introduces evidence that a printed representation of computer information or computer program is inaccurate or unreliable, the party introducing the printed representation into evidence has the burden of proving, by a preponderance of evidence, that the printed representation is an accurate representation of the existence and content of the computer information or computer program that it purports to represent."
Keep in mind, the date social media images are posted does not necessarily reflect the date they were taken. So further efforts will need to be exercised in determining and cross-referencing evidence, so the images serve an evidentiary purpose. Utility searches. Utility searches may be helpful, but in my experience, the utilities are usually paid by the party the residence is owned, leased, or rented by. Mutual financial assets and association. A great form of evidence is searching for the commingling of finances and mutual associations. A couple years back, I had a case where the supported party and the boyfriend purchased a car together, as well as a boat. Their names were listed on the registration and the loans. Additionally, they joined a yachting club together, listing their relationship on the application as cohabitating as opposed to roommates. In the matter of Rubin versus Rubin, 1987, the supported party, appellant ex-wife, Patricia Rubin, purchased a home with Gary Gutworth following her divorce from the respondent. The supporting party, respondent ex-husband, Stephen Rubin, sought a support modification order based on alleged cohabitation and prevailed in family court.
Upon appeal, the appellant stated her purchase of the household with Gutworth was a business relationship, and that personal living expenses were kept separate. Ironically, the appellant admitted that she shared the same bedroom, the same bed, and has had a continuous sexual relationship with Gutworth. The trial court found that Patricia Rubin's commitment between herself and Gutworth was much more substantial than she admitted, and determined that cohabitation did in fact exist. Appellant argued that the trial court's finding constitutes an abuse of discretion.
The Court of Appeal determined the present code section requires the court to find the parties were cohabiting, which clearly requires more of an analysis of the living relationships than merely sharing living accommodations.
In Rubin v. Rubin, the Court of Appeals concluded, based upon the evidence and the inferences reasonably drawn therefrom, the trial court found that appellant and Mr. Gutworth were cohabiting, as that term is used in Civil Code Section 4801. 5. Appellant's argument that she overcame the presumption of reduced need through uncontradicted evidence is without merit. There are numerous contradictions, both between appellant and respondent, and within appellant's own testimony. Those conflicts are resolved in favor of the trial court's ruling. The trial judge's ruling was both reasonable and sound, in light of all of the evidence before that court. The trial court did not commit an abuse of discretion by not affording the appellant's evidence as much credibility as she would wish. This court should affirm the trial court's decision and dismiss appellant's appeal.
The point of sharing this case research is so the investigator understands a cohabitation investigation requires far more due diligence than just determining if the two parties are spending the night together. Chapter 4: Surveillance and Documented Lifestyle. Surveillance will obviously be the most time-consuming and possibly cost-prohibitive, so it's necessary to have a solid plan and explain the reasoning to the client. I explain to the client that it is usually a 3 to 4 week process, and sometimes longer depending on the circumstances are and what the ongoing investigation reveals. Note, always use a camcorder with date and timestamp capability. With the advances in digital technology, in the form of quality cell phone camera images and apps, I have also incorporated using my cell phone with a free timestamp app that superimposes the date and timestamp on the image and incorporates the location as well, based on cell tower triangulation. Okay, back to surveillance. The first week is usually the most extensive. You will already have most of your background research in hand. The client hopefully provided you with routines or patterns of a supported party and possibly the known employment of the third party. Rarely does the client have the financial means to employ the investigator day and night, watching the residence of one or both parties, so it's important to develop a surveillance strategy. The plan is to quickly develop a lifestyle pattern, since most people are creatures of habit, which will allow the investigator, as time goes on, to refine the surveillance to particular days and hours, developing supporting evidence, while being cost-effective. You cannot, however, selectively pick only specific days to conduct your surveillance and not others. Example, only Saturday and Sunday, omitting weekdays. You must do surveillance samplings throughout the weeks. Years back, I had a client that wanted to argue cohabitation in court. The problem was the boyfriend only spent weekend nights at the supported party's residence and maintained his own separate residence during the week. Generally speaking, I will start early Monday morning until at least one or both parties leave, depending on the known habits and employment facts. I usually follow this with a lengthy afternoon and evening surveillance, documenting when they arrive, and then put them to bed, so to speak. Your goal is to establish their daily lifestyle through photographic evidence. I return early the following morning before they awake to document the vehicle locations are the same as the night before. It's important to note if there's condensation on the hood or in the windows. Chalking the tires can be okay to some extent, however. I prefer not being randomly caught doing so or leaving telltale signs that the tire was marked. The case will dictate whether this is a feasible option. If the client has the financial resources, I will sometimes conduct a 2 a.m. spot check, documenting the vehicles in the middle of the night. Chapter 5: Other Considerations. Things to note every day. 1. Document all vehicles and license plates at the residence. 2. Document vehicle locations. 3. Habits of neighbors, possibly interacting with both parties. 4. Mailman and delivery services, is a package left on the doorstep in open view, where the names can be read without touching the package. 5. Days for trash truck pickup, who brings trash receptacles to the street. 6. The clothing of the supported party and third party. Does the person staying overnight wear the same clothing the next day when they leave, or do they maintain a change of clothing at the residence? 7. Walking pets together, or does one walk the other's pet? 8. Engaged in what could be perceived as familial activities. 9. Does third-party drop-off and slash or pick up supported parties' kids at school? 10. Any signs of intimacy? 11. Access to the residence. Use of keys and garage remotes. 12. Does the third party intentionally park their vehicle away from the residence to deceive? After the first couple of days of surveillance, the investigator should have established a pattern or routine for the supported party and the third party, or boyfriend/girlfriend. From this point, the investigator, generally speaking, can reduce the surveillance to documenting arrival and departure times the following morning. Trash checks. Trash checks can be extremely useful in the form of evidence and leads for the attorney to subpoena. Searches can reveal junk mail to the address with either or both parties' names, possible bank accounts, printed communications, etc.
Note per California v. Greenwood, 1988. Trash receptacles located at the street-side curb to be considered discarded or abandoned. Here, we conclude that respondents exposed their garbage to the public sufficiently to defeat their claim to Fourth Amendment protection. It is common knowledge that plastic garbage bags left on or at the side of a public street are readily accessible to animals, to children, scavengers, snoops, and other members of the public. Moreover, respondents place their refuse at the curb for the express purpose of conveying it to a third party, the trash collector, who might himself have sorted through respondents' trash or permitted others, such as the police, to do so.
While the investigative point is proving cohabitation, the actual underlying legal issue is the reduced need for financial support. Does the former spouse live a lifestyle consistent with his/her personal declaration, income and expense decks, or is he or she living beyond their means or concealing relevant fact from the court? Aside from establishing cohabitation, the attentive investigator needs to be mindful of spending habits which may be revealed in surveillance and trash checks, unreported income in the form of cash jobs or personal cash-based business, possible routine gifted income from family, which can be factored as income. Is the supported ex-spouse employable? If claiming disability, is lifestyle consistent with claim of injury? Mail forwarding address form. As you near the end of the case, the attorney will usually subpoena the third party that may be living at the supported party's address. It may help support the case to check the third party's mailing address prior to serving the documents. With the deposition or witness subpoena in hand, complete the USPS mail forwarding address form. Each post office creates its own process or response policy, however. Regardless if you receive the document immediately or return in the mail, it will have the postal date stamp and completed for post office use only section completed, possibly confirming the address. This may be used as supporting circumstantial evidence. Witnesses. In the matter of interviewing witnesses, most neighbors will have knowledge, but are not willing to cooperate since they do not want to get involved since they have to live next to them. You also take a chance of tipping off the supported party, which will almost assuredly result in a change of lifestyle status. As a result, once alerted, it is not uncommon for one party to lease an Airbnb to give the court the impression they maintain a separate residence. Information gleaned from children via the parent can be a great source of information, but always try to follow up and independently verify their comments. In my opinion, no child should be forced into a courtroom to testify in cohab cases where they feel they're being disloyal to one parent or choosing sides, unless, of course, there is a child endangerment issue. But that's not what this article is about. Chapter 6, Investigative Report. Investigative reports and corresponding evidence can be voluminous in cohabitation matters. I prefer to write my reports, as I have this article, in plain English without cop jargon, written clear and concise, presenting the facts in chronological order, void of personal opinion. It should read almost like a story. I also prefer to write the report in third person by surname, not the investigator, to reduce reader confusion since there may be multiple investigators working the case. You should always assume the report will be presented as evidence and viewed by opposing party, as well as the judge or commissioner. Therefore, take your time to present the detailed facts in an honest, logical manner. Always advise your attorney of any potential leads established through the course of the investigation that may require a subpoena, loan docs, work and school records, etc. In closing, this article does not include all possibilities or investigative avenues, but is intended to demonstrate the depth and complexity of cohabitation cases. Additionally, this article should not be considered as legal advice, but rather an investigative guideline for investigators. I hope you find this article helpful in the furtherance of your family law knowledge and investigative capability.